Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me very quickly read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Welcome back, everyone, to Immigration and Jobs Talk Show, and also to today's timely and insightful discussion on the potential challenges to Trump's immigration policies, a topic that has significant implications for individuals, families, and businesses across the United States. Joining me is Jonathan Wasden, a seasoned immigration litigation attorney with a deep understanding of the complex and often contentious landscape of US immigration law. So, without any further ado, let me welcome John because John today will guide us through the legal frameworks and potential challenges to these policies. And we are going to delve into a lot of details, and we are going to have a detailed conversation. And to have that, I would like to welcome John. So, John, welcome back to Immigration and Jobs Talk Show once again.
Thank you. Good to be with you.
Same here. Thank you so much, John. So, John, let me just start this session before we talk about the legal aspects and before we talk about how we can challenge, what Trump's planning to do, or maybe how the attorneys can challenge and how the law can challenge. Let me ask you, what are your views? Because I think this is the first time after Trump has won, we are doing this show on with you on Immigration and Jobs Talk Show. So, what do you have to say? I mean, what do you think? Were you expecting this result? And personally, I mean, you were thinking that people are going to choose Trump over Kamala Harris?
Yeah, I'm a pessimist by nature, so I was expecting Trump to win just because I didn't want it to happen, I guess. But if you look at the states that are the swing states, it's a lot of rural white voters, which is not Kamala Harris's key demographic. So it wasn't terribly surprising that Trump won the way he did.
Right. And how much of a role do you think Elon Musk played? Because now I think a lot of people are also accusing him that he's taking away all the credit and not he. I mean, he supported and he endorsed Trump, but there were also other people who were supporting him. And now that he has won, he's taking away all the credit. So, what do you think about that? What do you have to say?
Well, I mean, I think tweaking the algorithm on Twitter did a lot to help Trump out. Definitely it elevated his news stories and gave him priority, and better visibility. So that actually I don't think can be underrated in terms of its effect on the election.
Right, right. And also, John, what do you think about his administration picks? He's picking a lot of people who are in the news, especially with I think Matt and Tom Hooman, and then we have they created a completely another department for Elon and Vivek Ramaswamy, just so he can appoint them under his administration. So, what do you have to say?
The Tom Homan pick makes sense, to be quite honest. He's somebody that has established that he is fit for that job. We can't say the same thing about Matt Gaetz. The guy is currently being investigated for all kinds of significant felonies, and he's now going to be the chief, cop in the United States, the chief law enforcement officer in the United States. So that's a head scratcher. And quite frankly, there's enough Republicans that don't like that pick that it could be he doesn't make it through the confirmation process. But the confirmation process will be incredibly ugly for him. And we see Trump already making waves saying that he needs recess appointment authority, which means he needs to be able to appoint people for a period of 6 months without Congress being involved. That's the only way I see Matt Gaetz making it through and actually getting in the seat at the Attorney General's office, because a televised hearing is not going to go well for him.
Right, right. And, we have already started actually getting comments. So I think I can take this because this is about the conversation that we are having right now. So RK is here and he says, do you see them using the regulations process going through all the steps to change the H1B regulations? How long would that work?
So there's a currently pending regulation that could be dropped at any day. So it's the modernization of the H1B program. They published their proposed rule, they took comments, and it's been pending for almost a year now. If that regulation, which is not great for H1B holders, goes through, the Trump administration could conceivably nullify it through the Congressional Review Act, the CRA, which allows the Congress to invalidate an agency regulation. The speculation is Trump might do that so that they can replace that regulation with something that is far more strict and stringent and lines up more with their policy objectives that they've articulated in Project 2025.
Right, right. I mean, there's a lot that he can do. And but what do you think? Do you think it is also going to impact because I think the Biden administration, they allowed H4 workers, I mean, the spouses, H1B spouses to work, right? And now that
Mhm.
Trump is back, he's trying to cut down on H1B visas. So do you think it is also going to affect the H4 visas as well?
Most definitely. The two things that are on the chopping block will be student work programs, the OPT and STEM OPT programs, as well as the H4 EAD. And the way that they'll attack that, it has to be repealed through the regulatory process. So they'll have to post notice of a proposed rule revoking those regs, and then take comments, and then come out with a final rule. All of that takes quite a bit of time. And if you'll remember in the first administration, when they published their regulatory agenda, number one on the list was repealing the H4 EAD. They tried to do it for 4 years and they could never quite get it through. But what they did realize is that if they toy around with the processing of the H4s and create new requirements for processing internally, they can dramatically slow down the H4 EAD and achieve the same effect that they would have through an actual legal process of creating a regulation. So I would expect them to do something similar this time around, but illegally killing the program, but in a way that is not facially killing the program, more of a behind the scenes way of doing it through processing delays.
Right, right. And but do you think that it can also be legally challenged? I mean, because I'm pretty sure that um, the H1B, the employers and maybe the employees, they might try to do something for the H1B visas, but for H4 visas, do you think that can be legally challenged in the court of law?
Well, definitely a regulation that's repealing the H4 EAD could be challenged. There's a whole body of law that says that when the government does an about face and does 180 on a policy and regulation, they have to go through certain additional steps that don't exist for a new concept or a new rule. So whether or not the agency will be able to satisfy that test remains to be seen, and whether or not a court would agree that they've failed to comply would be another question. The other thing that is interesting about the H4 EAD is there's a special threshold, the dollar impact of a regulation, and if it hits that dollar impact, then additional processing rules could kick into play for the regulation. And the H4 EAD economic impact is probably significant enough that it's going to hit that threshold, which makes it harder to repeal. And I think that's the problem they ran into the first time around in the first Trump administration, is they kept bumping up against that economic impact analysis.
Right, right. Okay, so I'm also getting a lot of questions from other people too. I mean, RK is again here with a follow up. Then Mohan Das is here. Hi guys, we're definitely going to take your questions. And please note down that we're not only live on YouTube, but also on LinkedIn, Twitter, Facebook, and the handle is Immigration Talk Show. So don't forget to subscribe to us. And yes, if you have any questions, please post them in the comments below and we'll be glad to take them. Now, RK actually has a follow up, John, which I would like to read. He says other regulations like the unpaid OPT, could they do a new regulation to change that? That it has to be paid similar to STEM OPT?
Yes, they could accomplish a lot of things through regulation, and they could tweak and alter the rules. Now, the unpaid OPT, changing that to a paid requirement, isn't really an about face. It's not a 180 or a reversal of policy. It's just more of a program tweak, I would say. So I think that's something they could easily achieve through regulation. And I say easily achieve. Getting regulations through the process is not easy. It takes time and it's very difficult. So, in terms of regulatory process, it's something that I think would withstand challenge in court pretty easily.
Okay. Thank you for answering the question, John. Asim also has a question which is very similar to what I was about to ask you. So, Asim, I don't think so. I'll have to take your question because this is a question that I already have with me that I wanted to ask John. So, John, now let's talk about what Trump and his administration plans to do. And very first thing that comes to mind is travel bans, right? And especially to the Muslim majority countries. So if you can please tell that what are the legal grounds for challenging Trump's entry bans and how have past challenges to similar policies fared in court?
Yeah, so the first thing I would say, if you want to be in the United States, get here before the 20th of January. Once Trump takes office, he has a pretty impressive array of authorities when it comes to admission to the United States of foreign nationals. And that authority runs from completely closing the border down to creating new criteria that limit access to the country for certain categories of people. The first time around, we saw this happen. And their first attempt wasn't successful when it was challenged in court because it was based solely on religious criteria. And the courts weren't terribly wild about that. So they went back and they created a new justification for the same basic rule, which was people coming from these listed countries have a higher incidence of terrorism risk, so we need to exclude them for the safety of the U.S. Same effect, different rationale. The different rationale allowed the ban to stand in place. I would expect Trump 2.0 to do something similar. I think they've learned from their mistakes on the first time around, and if they're going to shut down the border, they're going to do it in a way that is facially generic and not discriminatory, but the impact will be the same as what they want to achieve.
Okay. So I mean, most possibly, I mean, it is going to happen that then.
I think we'll see some type of border restriction.
Okay.
Within the first day, if not week, or if not day of the Trump administration, we'll see some type of clamping down at the border.
Right. And now that you have mentioned border, I also would like to know, before that, Wajid has joined us, Nikhil has joined us. Hi, Nikhil and Wajid. Thank you so much for participating and for, posting your questions. We are definitely going to take your questions, but in a while, let me just quickly ask the second question and then maybe we can move to your question. So, John, now that you have mentioned border, I would also like to know from you, how might the incoming Trump's administration plans to use military funds for extensive holding facilities and deploy troops at the border be legally challenged?
So there's an entire body of law called fiscal law. And fiscal law is supposed to limit the way the executive uses money. And if under the traditional interpretation of the law, if Congress has earmarked money for a specific project or issue, it can only be used for those purposes.
Right.
So when the Trump administration diverted military funds that had been earmarked for military use for the border wall back in his first administration, I, applying just the standard tenets of the law, thought for sure that that would get shot down. However, at that point, they were lucky in the judges that they got, and they successfully found a loophole with the court to allow the diversion of military funds to go fund the border wall. That precedent still stands, and I think we'll probably see him try and exploit that even further and use earmarked funds for other purposes than what they're actually supposed to be used for.
Right. And with now Tom Homan being bought as czar, how do you think that is going to affect it?
Let's just say I wouldn't want to be crossing the southern border. I think that's going to be an inherently dangerous and miserable experience by design. I think they're intentionally going to make it as miserable as possible to deter people from coming.
Wow. Okay. So now with this, I would like to give a little break to my questions and maybe move to our audience's questions. So let me quickly take Nikhil's question. So Nikhil says, how difficult to get H1B change of status if enrolled in F1 Day 1 CPT course?
So change of status just really depends on if you've maintained status. So if you've been maintaining your status, the change of status shouldn't be a problem. Now, if the agency is going to take issue with your Day 1 CPT program, they're going to have to put that in a notice of intent to deny or RFE, asking for evidence that you have maintained your status. And if there's no real program violations, if you're complying with the CPT rules, you should be fine.
Okay. So thank you so much for your question, Nikhil. If you have a follow-up, please let us know. Please continue posting your question. And yes, I will be more than happy to take it. And then let me now take Wajid's question. So Wajid says, for such immigration scrutiny, for H1B, H1B extensions, and H4, with reforms and new rules, what is the probability for such laws to be struck down by the court?
So it depends on, obviously what the new law or rules are and how they're implemented. If they, create a policy memo that has a standard in it or a requirement in it that is contradictory to the law, then it's very easy to get that shot down, and the courts will shut that down. What's going to be more difficult and is going to take a lot more preparation is if they create processing requirements that basically kill the visa petition or visa application.
Mm-hmm.
Then, those processing requirements are much more difficult to challenge. You have to go with the Mandamus Act, and you're going to need to do some work in advance. And we're already starting to put together the Freedom of Information Act requests that we're going to need for the evidence to do this type of litigation, because I really anticipate they're going to use delays as a way of ending your benefits as an H4 or an EAD, and even potentially slowing down the H1B process so much that it causes a lot of disruptions in work authorization.
Right. Okay, and he also has a follow-up where he says, to change the 14th Amendment of Constitution for the birthright citizenship, I believe it needs 2/3 of vote in Senate as well as House. Do you think this will go through?
No. The constitutional amendments are ridiculously difficult to manage and get done. You see Congress right now can't even get any substantive legislation through. Getting a constitutional amendment through and through the entire process that it has to go through, highly unlikely. So I wouldn't expect that to happen. What I wouldn't be surprised to see is the Trump administration trying to deny birthright citizenship through some type of executive order or regulatory change. And I think that'll ultimately lose in court.
Mm-hmm.
That doesn't mean they won't try it. And it doesn't mean it won't cause a lot of disruption for people who are in that situation, and it's going to require them to fight it out in order to protect their rights.
Right, because I think, this is what first term, he and his administration, they also tried to completely dismantle and completely terminate DACA, right? And
Mhm.
because they weren't able to do that, so they had to put a ban on it.
Yeah, so DACA is one of those things where you have to explain why you're doing your reversal of policy, and that's where
Mm.
they ran into problems with that.
Mhm.
So, but DACA is regulatory. It's an executive action. It's not something that is in the Constitution.
Ah, right.
Changing something in a statute is difficult. Changing something in the Constitution is infinitely more difficult.
Right, right. And I think now that Trump has won, people have also started reading the law. So now people are talking about the 14th Amendment, and that's what Wajid says, right? So now it's good to know. Wajid, if you have any
Yeah.
more if you have any more follow-ups, please continue to post them. We'll be definitely are going to ask them from John. And yeah, John, would you like to add to that?
I was just going to say that the trending Google searches really betray a lack of informed voters in the United States. I think one of the top trending Google searches on election day was, did Joe Biden drop out?
Mhm.
And now the trending searches are things like, what is a tariff and how does it work? And
Mhm.
people are finding out for the first time exactly why voting for Trump was against their own interests. And the education process really should have happened before they voted, but now we're stuck with it.
Yeah, maybe, better luck the next time. Maybe the next time they will choose better, right? They
Yeah.
will educate themselves more in these 4 years, and then they can choose a better person or a better, party. Um, okay, so now, John, coming back to my question. So, I would also like to know from you that what are the potential constitutional and human rights violations associated with Trump's entry ban policies, and how can these be argued in court?
So for the entry ban, the Constitution and the courts both have given the executive very wide discretion on allowing foreign nationals into the United States and determining who can stay in the United States. So, there's not a whole lot of constitutional protections. They just really have to do it they have to structure the ban or the prohibition on admission to the U.S. based on factors that are not sex related or religion related. They're allowed to discriminate based on country of origin with immigration law, and so they've really got to just avoid two big hot button issues, and they should probably be upheld by the court.
Right, right. Thank you so much for answering the question, John. Now I would like to actually come to H1B because I think H1B is the one that we were talking about in the beginning. So, John, what do you think? What could be the most pressing issues for employers if OPT or H1B caps are further restricted?
So right now, as it stands, obviously nothing's changed, and there is a pending regulation that could change things significantly.
Mhm.
I think what will be facing in that pending regulation is changes to the way that consulting company applications or petitions are done, changes to the employer-employee relationship test, and also changes to the definition of specialty occupation. Those are all things that are going to be challenged in court, and I think the agency's likelihood of success is pretty low on a lot of those issues. But like I said earlier, the speculation is that regulation might not get published or not be in full effect, and might get replaced with something that is far more stringent and far more drastic for H1Bs. The things that the Trump administration will almost certainly do is what they've tried to do in the prior administration. uh, Alter the H1B selection process to favor those with the highest education and highest salaries. And so I would expect that to go into effect, which will cause, a bit of a bidding war for salaries in the H-1B program. So ultimately, I think it will help a lot of H-1Bs, make more money, but it will probably price out a lot of the smaller companies out of the H-1B process.
Wow. Okay, but do you think, are there any sectors where where we can expect the impact of these changes to be particularly severe?
I think we will see probably some new policy memos that direct adjudicators on how they decide petitions or how they process petitions. I wouldn't be surprised if they try and reinstitute things through policy memo that the courts have already told them they can't, just to see if they have a better chance this time. But really, it just remains up to be seen what they're going to do specifically. And if they're going to try and create a new regulation. In their Project 2025 document, they discuss replacing the existing temporary worker regs with an entirely new system. So obviously that's a complicated endeavor, and it will require a lot of time to get that reg in place. I'm sure there's a draft regulation that they've already created with Stephen Miller, and they just have to go through the process of getting it noticed to the public, take in comments, and then publish a final rule. But all of that would take at least 2 years, would be my guess.
Right. Okay. Thank you so much for answering the question, John. Now I would like to come to, APA. So if you can please tell us that, can the Administrative Procedure Act, APA, be used to challenge the legality of these policy changes? And if so, how?
Yeah, so the APA, just for background, is basically the handbook that the government has to follow when they make rules or make decisions administratively. The APA focuses on, just it's in the name, on procedure. So there's a lot of things that they can do substantively that are stupid, and the courts will uphold them, and it won't be in violation of the APA if they follow the right procedure. Now, some decisions are so stupid that courts might find that they violate procedure just because they're so bad. But 99% of the time, if they check the right boxes, the courts are going to uphold the agency's decision or rules that they've created through regulation. So the APA, it will help us, especially in light of some changes that the Supreme Court has made with regards to interpreting APA decisions. The Loper-Bright decision and the Kaiser decision both have given courts a lot more authority and discretion to decide, what is within the bounds of the statute and what the agency has jurisdiction to do, and what is outside of the bounds. And it's given a little bit more power to courts to decide, whether or not something is too stupid to go into effect, or whether it violates the intent of Congress when they created the statute. So I think those decisions, especially with the right judges, are going to be very helpful in challenging a lot of what the agency is planning on doing, or the Trump administration is planning to do.
Okay. And what legal avenues are available to challenge delays in processing immigration petitions, such as, those for employment-based visas or family-based petitions?
Yeah, so the processing delays, I think, are going to be a real issue. The first thing that needs to happen is Freedom of Information Act requests looking for processing data. How have they historically processed these things? How quickly? How many applications have they dealt with in a given period of time? And then FOIA requests looking for current data. And so, we want to establish a baseline with evidence, and then we want to move forward and see how the environment has changed to show that the government is actually intentionally slowing the process down. And all that is done under both the Freedom of Information Act lawsuit as well as a Mandamus Act lawsuit. And so you combine those two cases together, to fight those, intentional delays that the agency has created.
Okay, but are there any specific case types, John? Maybe like asylum or family reunification where delays are like especially severe?
Yeah, so, you look at the type of immigration benefit on a sliding scale.
Mhm.
And the more long-term a benefit is, if it's talking about a 485 adjudication or something like that, the courts are going to be more forgiving of an agency delay. Same with asylum. They're going to be more forgiving for long processing times because there's a lot of back checks that have to go into the decision-making process. For your shorter term applications, I think the courts historically have been, less sympathetic to government delay. Because a permanent benefit like a green card doesn't ever expire, right?
Mhm.
But a temporary benefit like an H1B or an H4, it has an expiration date of a maximum of 3 years. And so, the courts aren't going to allow the government to just sit on applications for an entire 3-year period just to moot it out. So I think we'll probably get more help from the courts on fighting delays in the non-immigrant visa categories than we would in something that leads to a green card.
Okay, okay. But what types of relief can, the affected applicants they can realistically hope
Mhm.
for, if their challenges are delayed?
Yeah, so if they're filing a mandamus case, and they're successful, they get an order from the court that tells the agency that they have to make a decision on the application within a certain period of time. So that gives them some certainty as to when they'll receive a decision. Now, it doesn't direct the agency on how to decide. So the agency could, get that court order, and conceivably they could deny it. Historically, though, they're unlikely to do that because that judge is going to probably retain jurisdiction over the case if they challenge the denial in court. And if the judge has already ruled against them once in that particular case, highly unlikely they want to roll the dice and try that again. So I think if you win your mandamus case with a court order, life should be quite a bit easier for you.
Okay, okay. Now that you have mentioned mandamus, I would also like to know from you, John, that what role can, you know, uh, okay, I think, okay, how can applicants and their attorneys use mandamus actions or judicial review to address unreasonable delays in petition processing?
Yeah, so the Mandamus Act is, taking a thing from old common law in England that says that, if the government has a non-discretionary ministerial duty to do something, the court can order them to do it. And, proving a non-discretionary duty to do something is a seemingly high standard under the law. The Administrative Procedure Act has a unreasonable delay provision, which is a lot more forgiving, and the standards seems to be a little bit lower. And as long as you can show that it's not unreasonable using 6 different factors, that's how the court's going to decide the case. In reality, even though the 2 standards look different on their face, the courts treat them exactly the same and they process them the same way. So using the APA or Mandamus Act is going to be one way to fight unreasonable delays or prolonged delays.
Mhm.
The trouble with an ordinary delay case is, some people think it's as simple as saying, here's the average processing time, I've gone over the processing time, therefore I win. But history has shown that approach is not the most successful way to do it because the government has all kinds of defenses that they can throw in. So if you're going to be going down the road of, filing a mandamus case, you need to do something additional to get the evidence you need to fight your case on fair grounds. And that's the Freedom of Information Act request. And if you file that FOIA request and then you sue the government for production of the documents and the evidence in that request, then you'll have all the evidence that you need to fight the government on a delay lawsuit. And that's really going to be important, I think, especially with the Trump administration, that people really think out their lawsuits for mandamus and work hard to get the evidence that they need to win. Because those cases, to be frank, are quite honest to win in front of a judge.
Yeah, right. And then what role might the APA play in challenging the legality of Trump's deportation policies? And how can advocates argue that these policies are arbitrary and capricious under APA?
So again, if they go through the regulatory process, changes are going, as long as they don't contradict the statute, most likely the changes will be upheld. With deportation, there's a provision in the law and the statute that Congress created that strips courts from judicial review of just about all deportation decisions. And the only way you can, challenge a deportation decision is, you first have to appeal to the Board of Immigration Appeals, and then you appeal to the Circuit Court of Appeals for the jurisdiction. There's not going to be any district court challenges to removal orders or deportation orders that is going to make it through. The district court is a trial court level. So, as long as they check the boxes right in creating a new regulation, as long as the new regulation doesn't conflict with terms in the statute, I think changes to the deportation process are probably going to be upheld.
Right. And there are, I think they said that there are almost 11 or 13 million people who they are planning to deport, right?
Mhm.
So, do you think it is possible to actually deport these many, John? What do you think?
Yeah, so there's the question of how easy it is to do something and create a new rule. And then there's another question of putting that rule into effect. And the practical reality is, that is a large number of people. And just, rounding that many people up, detaining them, running them through the process, and then deporting them is an incredibly expensive proposition. And so, Congress is going to have to authorize, additional funds for that, which is going to be a problem because Congress can't decide anything. Or they're going to try and divert money from the military budgets. One proposal that the Trump administration has floated out there was federalizing the National Guard to carry out a lot of these enforcement actions. That has its own problems. There's something called the Posse Comitatus Act, which basically says the federal government can't use the military to enforce civilian law. And so if they try and federalize the National Guard, I think we will see a lot of lawsuits under the Posse Comitatus Act. And I tend to think those will be successful lawsuits.
Right, or maybe Elon Musk can help them, right? Now that he's completely endorsing, and within a span of, I actually read somewhere that within this span of after Trump won, within this 1 week, he actually his company actually earned somewhere around 55 billion in a span of 1 week. So yeah, you never know, right?
Yeah. And I would expect that we'll probably see tax cuts for people like Elon Musk in the future to pay him back for that.
Yeah, right. Now that they have created a whole new department for them, what do you know? They can do anything. So Skid Row is also here, John, and he has a lot of questions. Let me read his questions. He says Mexican cartels as Americans, immigration officers running America's immigration is illegal. 16 million illegals, 3 million illegals gotaways. 2 million homeless Americans come before millions and millions of illegals. Legal immigration is different than Mexican cartels, human trafficking. Legal immigration in coming in through a port of entry, not in run by Mexican cartels. Okay, so head of Homeland Security, Mayorkas is a criminal human trafficker. 15 million people with free healthcare, housing, food, airfare cost more that flights out of America. What do you have to say, John?
There's a lot there to
Yeah.
unpack. I'm not quite sure what the question was, but um, you know, illegal immigration is definitely a problem, and there's a distinction between legal and illegal immigration in the law. Unfortunately, when politicians talk about immigration, they don't make that distinction very well when they're talking with voters. And, you know, voters in this country, when they hear the word immigration, they're not thinking of, somebody with a PhD or, a computer science expert that's coming to the US. What they're really thinking about is somebody coming across the southern border, wearing a sombrero. And that's their vision of immigration. And, there really needs to be a better education by the immigration, bar, the Immigration Lawyers Association, to make that distinction between legal and illegal immigration and focus on the positives that legal immigration has for the country. That's an education project that is long coming. It should have been done decades ago, but hopefully they'll see the light and they'll get that done.
Yeah, I think Skid is very sad and angry, how you call it, maybe sangry, and he's just venting it out. So thank you so much, Skid, but, for your comments. Now let me quickly take Wajid's question again because he's back and okay, for some reason I'm not able to show it. Okay, now I can, I think. Wajid says, changing the definition of specialty occupation to directly relate to the highest level of education. Number two, changing H1B wage requirements, for instance, like $120K per annum as a minimum requirement. How is it possible? How possible is for such rules to pass in court of law?
So for the prevailing wage to be changed, that has to go through the Department of Labor, and they just have to go through and do the right statistical analysis and economic analysis to make sure that the prevailing wage that they're stating, or the process to get the prevailing wage, complies with the law, and it is the true prevailing wage for the location. I think the prevailing wage laws, as long as they don't go too extreme in the regulation, I think that'll probably be upheld. But in terms of reorganizing the H1B lottery with USCIS, I think they could potentially create a new system that prioritizes those with the highest education and highest wages to be first picked in the H1B lottery. I think that's probably something that would also withstand challenge, and for a lot of reasons. One is that I think most Americans think that makes sense. That why wouldn't we want to prioritize getting the best and the brightest into the U.S.? So I think that's something that's very likely to come in through the regulatory process. And I think ultimately restructuring the lottery based on those requirements is probably going to pass.
Right. All right. Thank you so much, Wajid, for your question. And let us know if you have another follow-up. I hope you've got the answer. And in case you want to get in touch with John, so his details are, scrolling below. You can give him a call on his number, which is 844-592-7336. I would like to repeat the number, 844-592-7336. You can also email him at support@wasden.law, and you can also visit his website, which is wasden.law. Thank you so much for your questions. And John, before I move to other viewer questions, I would also like to ask you that, do you think it is also possible for the Trump administration to also end the birthright citizenship? I mean, that's what they say, that they are going to end that. I mean, the children, if the parents are undocumented and don't have the legal papers, and if they have a kid in the US, then they're also not going to get the citizenship. Do you think it's possible for them to end it?
So I think it will require a constitutional amendment, which is highly unlikely. but that doesn't mean the Trump administration won't try to do something, administratively first. And I can see a scenario where they create a new policy or regulation saying that they won't grant, passports or benefits to anybody in that situation. That's going to have to go through the legal process and challenges. And I think challenges to that policy or that type of regulation are going to be upheld. I think, the government will lose that issue if they try and take away birthright citizenship administratively. Even with a statute, I think it would fail the test because the statute can't conflict with the Constitution, and the Constitution seems to be pretty clear on this point. So I don't think they will ultimately be successful. That doesn't mean they won't try.
Right. Well, thank you so much for answering the question, John. And we were talking actually about APA before. So I would also like to know from you that are there any recent examples of APA challenges to immigration policies that could, serve as a model for future litigation?
So if you look at the last couple of fee regulation lawsuits and the prevailing wage lawsuits, I think those give us a pretty good guide. Those are things that the Trump administration lost in their first term, just for failing to follow proper procedure. And I think there's a lot of roadmaps out there for how to fight new policies and new regulations.
Okay. Thank you so much for again answering the question, John. I still have questions pending from Mohan that I would like to take. So Mohan says, given the potential reforms to the H1B visa program, including stricter eligibility criteria and priority for higher wage workers, what strategies can employers and applicants use to navigate these changes? How can we prepare for potential delays and increased scrutiny in the application process? I think this is something that we already have discussed about, but John, if you would still like to give an answer.
Yeah, so we have to see exactly what those changes are when they happen. Yeah, just because they're suggesting it now doesn't mean it's obviously in effect right now. So for right now, the rules stay the same. If they do create a new regulation, then we'll have to look and see what the actual language of that reg is. But by all accounts, the intent of the Trump administration is going to be to rack and stack H1Bs based on the level of education and the level of the wage, and also on the level of technical skill required for the job. So if you have somebody who's the world leader on a specific topic and they only have a master's or bachelor's degree, they're probably going to be just fine getting an H1B and making it through just because of their technical expertise.
Okay. Let us know, Mohan, if you have a follow-up. I hope you've got your answer. But John, you're an attorney, so I would like to ask you this question. So, how does it affect the attorneys also? Because you are the one who are taking care of all these things. And, then one government comes, they plan to ban everything. And then the other government, after 4 years comes and they plan to release the bans. And then, it definitely must be affecting the attorneys also, right? So how do you guys take it?
I think most attorneys right now are taking a deep breath and waiting for January 20th to come because we're not going to be able to take a rest for 4 years. I think the petition and application process is going to be far more difficult than it was previously. We're going to see a lot more requests for evidence and a lot more NOIDs or NOIRs. And there's going to be new requirements for the employment-based visas, for the applications that we're going to have to contend with. All of those things are regrettably going to drive up the cost of immigration practice for the individuals, just because there's going to be a lot more work that goes into the applications.
Right. So maybe you guys can, have a good Christmas, good holidays, relaxing holidays and Christmas, because then from January, as you said, from 2025, it's going to be pretty hectic for you guys, right?
Yeah, it's not going to be a pleasant experience, that's for sure.
Right. Okay, so let me quickly take Neha's question also. So Neha is also here. She says, I'm trying to understand the cost and time involved in challenging policies like an H1B denial or travel ban in court. How long does it typically take to see results? And is it worth pursuing financially, or would it be better to wait for policy changes under the new administration?
So if you have an H1B denial or any type of application denial,
Mhm.
the process is you file a complaint in federal court. The government has 60 days to respond. And typically on a denied application, what they will do is produce what's called the administrative record, which is all the documents they relied on in making their decision. And then the court will order a briefing schedule. The plaintiff's counsel will write their motion for summary judgment. The government opposes it, and then you reply. And that process probably is going to take, upwards of 8 months if the government fights it out all the way through. If you're talking about a challenge to, say, a travel ban, that's going to be a far more efficient and far quicker because you're only dealing with legal issues. You're not dealing, with a lot of facts or administrative record. You're just litigating whether or not the executive branch has the authority under the law to do something. And those are usually done on, expedited motions like preliminary injunctions or TROs. And you'll see, start to finish, those things will take a month or if not quicker. And then in terms of, challenging regulation and policy, that's a long process that it probably is going to take, upwards of a year.
Okay. Thank you so much, Neha, for your question. I hope you've got your answer. Let us know if you have a follow up. So, John, here is a very controversial, I don't know if I should say controversial, but a statement from Skid, because he's been continuously posting his opinions and what he feels, I think, in the comment section. But this is something that I would actually like to read. I don't know if you would like to respond to it or not, but let me just read it for the people. He says there is $1 billion business having pregnant women flying in and having their babies in America using the law that was created during World War II. And there is no question; it's just a statement. So, I mean, would you like to say something to this? If not,
I don't
maybe.
know what law he's, yeah,
Uh-huh.
I don't know what law he's talking about for World War II, but birthright citizenship goes back to the Civil War amendments. After the Civil War, the 13th, 14th, 15th Amendments were put into the Constitution. And that's where we get birthright citizenship. So it's not a new thing. In terms of the $1 billion industry, I have no, firsthand knowledge of that. Um, is it possible? Yeah, it's conceivably possible. But, it's probably not the biggest concern that we've got in the immigration business. And we've got a lot more pressing concerns than what would be a relatively small handful of people that can afford to fly here and give birth and pay expensive hospital bills and then get citizenship for their child. And we've got a lot of bigger fish to fry in this country first.
Right, absolutely. And with that, now I would actually like to talk about undocumented immigrants a bit. So, John, what strategies can be employed to protect the rights of undocumented immigrants, particularly those with long-term residency or family ties in the US?
So if they are eligible for any type of relief, any type of asylum claim, anything like that, they should definitely preemptively start filing those applications. Don't wait for ICE to show up and then do defensive asylum claims. The ICE removal process is going to get a lot more aggressive than it has ever been, I imagine. And so being proactive, I think, is the best policy for people in that situation.
Right. So thank you so much, John. I think I still have a lot of questions. I do, but I don't know if you have enough time. So if you have, I think I can take maybe a few more.
Okay, sure.
Okay, great. So, John, talking about these families, so how can these families prepare legally to defend their status, in case of, increased enforcement?
So, if they're here illegally, they don't have status, which makes it very difficult. Historically, the way that the government has done removal or deportation is that they kind of have a priorities list. These are the types of people that we want to focus on, removing from the country. And, the top of the list are, people that have extensive criminal records or, ties to terrorism, things like that. I think the list of priorities is going to be far more extensive than it was before. And we're going to be seeing, deportation go far further down on that list of priorities than it ever has been before. So in terms of protecting themselves, if they have assets in the country, I would say have a plan in place, have powers of attorney in place, so that if you do get removed, you can dispose of your assets or get them transferred so that you don't lose out everything you have financially. But in terms of, immigration status, look and see what you can possibly qualify for. But if you don't qualify for any type of visa status or asylum or something like that, there's not a lot of good options.
Right. Now, also, John, given the likelihood of increased enforcement action, and what advice would you give to individuals who might be at the risk of deportation, and what legal resources are available for them?
I would say anytime you're dealing with an immigration officer, don't try and wing it. Get somebody that knows what they're doing. Get a lawyer on your side that knows the process, knows the rules, knows the law, and can guide you through it. Probably best to start shopping for a lawyer now. If you're in that situation, find somebody that's an expert in removal proceedings and removal litigation, so that if the worst happens, you're ready and you've got a phone number, you've got a name that you can call or your family can call on a moment's notice.
Right. Because after now that Trump has won, and he and his administration is going to put a lot of scrutiny, for these visas. So, guys, make sure that you are in the right hand, and make sure that you get in touch with the right kind of attorney who can help you with your case, or not just anyone. And you can, and if you are looking for one, just directly get in touch with John himself. You can give him a call on his number, which is 844-592-7336. I would like to repeat the number, 844-592-7336. And you can also email him. His email ID is support@wasden.law. And you can also visit his website, which is wasden.law. So yes, make sure to get in touch with him regarding your cases. Thank you so much again, John, for being here. It was great having you. It was a great conversation. And thank you so much for, again, taking our time and doing the show. Hoping to see you very soon back.
Thank you. Have a good one.
You too. Thank you so much. Thank you so much, guys, for being here. Thank you so much for your amazing questions. And we are going to do another episode with John very, very soon. So make sure that you are subscribed to Immigration and Jobs Talk Show. But for now, I'll have to take your leave. Thank you so much again for being here. I'm Rajni Bharara signing off for now. Take care and keep on subscribing and keep on watching Immigration and Jobs Talk Show.